Welcome to Hannity, and this is a Fox News alert. The Supreme Court of the United States delivered a major blow to President Obama's health care law today and a major victory for religious freedom. In a 5-4 decision, the justices ruled in favor of the Hobby Lobby craft chain, saying that closely held corporations can in fact opt out of the Obamacare contraception mandate due to religious objections. Now, the decision marks the first time the Supreme Court has ruled that profit-seeking businesses can in fact hold religious views under federal law. Fox's own Shannon Breen, she is in Washington tonight with the details. Shannon.
Well, Sean, in that 5-4 opinion, the Supreme Court sided with the devoutly religious family owners of 2 for-profit corporations, holding that the Religious Freedom Restoration Act, or RFRA, protects them from forced compliance with a government edict the family say is in direct conflict with their most deeply held religious convictions. For more than a year and a half, the Green family, those are the founders and owners of the Hobby Lobby craft store chain, has been fighting this government mandate stemming from the health care law, a federal regulation that would force them to provide their employees cost-free access to 20 different forms of contraception, including 4 methods the Green family believes can trigger abortion, something they refuse to do. But that refusal could result in fines in the range of $475 million a year. Writing for the majority, Justice Samuel Alito said this, quote, "We hold that the regulations that impose this obligation violate RFRA, which prohibits the federal government from taking any action that substantially burdens the exercise of religion unless that action constitutes the least restrictive means of serving a compelling government interest." Responding to today's decision, Hobby Lobby co-founder Barbara Green said her family was, quote, "overjoyed," adding this, quote, "The court's decision is a victory, not just for our family business, but for all who seek to live out their faith." Justice Ruth Bader Ginsburg, writing for the dissent, said the court got it all wrong. Quote, "In a decision of startling breadth, the court holds that commercial enterprises, including corporations, along with partnerships and sole proprietorships, can opt out of any law, save only tax laws, they judge incompatible with their sincerely held religious beliefs." Now, both the White House and several Democratic members of Congress are vowing to take action in response to today's opinion. One of the first proposals comes from Democratic Senator Dick Durbin, who wants to require corporations that limit contraceptive choices to be forced to disclose that to all employees and anybody who applies for a job at the company as well. Sean.
All right, Shannon in Washington tonight. Thank you so much. We're going to have more on the Hobby Lobby decision in a few moments, but also breaking tonight. Joining me with more on the monumental Supreme Court decision in favor of the company Hobby Lobby and against Obamacare, we have senior counsel at the Becket Fund, Hannah Smith, is with us, and from the American Center for Law and Justice, Jay Sekulow. Hannah, let's start with you. Let's get reaction. A big victory by any objective measure for religious freedom today.
It was a great day, both for Hobby Lobby, for the Becket Fund, and for religious freedom.
Yeah, well, explain why, in your opinion, look, 5-4 decision, still a 5-4 decision, very, very close. But I think the arguments of the majority were very solid, and that is that your religious freedom doesn't end just because you're part of a corporation.
Well, that's exactly right. And the majority opinion written by Justice Alito, joined by the 4 conservative justices, said that just because a family opens up a business, they don't lose their religious freedom rights. And that RFRA, the Religious Freedom Restoration Act, protects them when they open up this family business.
Were you hoping for perhaps a wider interpretation that would have extended to any corporation?
You know what? We actually got a great opinion today. Justice Alito's opinion was excellent on all of the major points. You know, he said not only do these family-owned businesses have religious freedom rights, but this is a substantial burden that the government has placed on them by assessing them these huge fines if they don't comply with the mandate. So he said that they have a substantial burden. And then he went on to say, you know, the government probably has a compelling governmental interest here, but they could have achieved this in such different ways than going about trying to force these religious objectors to pay for this mandate. So they said there was a less restrictive means of accomplishing this goal. And because there was a less restrictive means, this mandate just simply cannot stand.
You know, if you look at the 3 decisions, Jay, if we go back to the recess appointment decision last week and Harris versus Quinn about union members not having to pay dues, in this particular case, when it covers, you know, union costs, that was a big ruling today. In the Hobby Lobby case, the 3 things that you think that they have in common, or the common thread here, is that government has gone too far, that this is about government overreach, about separation of powers, co-equal branches of government, and a president that doesn't seem to put a lot of stock in what his constitutional limits are.
Well, you know, the president's theme was, yes, we can. The Supreme Court said today, no, you can't. And they said that last week as well. And, Sean, you're exactly correct. This is really the common theme here is a government overreach. It's a president that's operating the idea that he can not only be president and executive, but also legislator, and he doesn't get to do that. You look at the case involving the challenge to the recess appointments. That was a huge case last week. We represented before the Supreme Court the Speaker of the House in that case, and it was their job, the House and the Senate, to determine when they're in recess, not the president. Supreme Court unanimously rebuked the president's overreach on that one. You take a look at the union case you mentioned today. I mean, people need to understand, and obviously the Hobby Lobby case was a gigantic victory, so it overshadowed the labor case, but you had the state of Illinois saying that a mother taking care of her child at home that gets a small state subsidy constituted a state employee only for the purposes of union agency fees. And the Supreme Court there said, no, you don't get to do that. And this, go ahead.
Well, let me ask you about this. Between the recess appointments that the president has made, changes to his own signature bill, Obamacare, without going back to Congress, not enforcing immigration law, eliminating work requirements for welfare, he can't do these things unilaterally. Now John Boehner's taking it a step further. He's suing the president. I would argue may not have standing because they have some constitutional authority not to fund these things. But there seems to be a consensus here from the court that this president is not living up to his oath as it relates to the law and the Constitution.
I think that's exactly correct. What the Speaker is talking about is a president that said he's going to operate by pen and phone. And that's not the way the Constitution's set up. Now, you're right. There's a legal question regarding standing, and that's going to be something the courts will have to decide. But the merits of the case, the principle of what the Speaker's talking about, is this consistent pattern of government overreach. You know, you can look at the IRS scandals and all of these, and it's that common theme. They overreach, they get caught, they pull back a little bit, but then they move it right forward. Now, I'll tell you, in this Hobby Lobby case today, though, I don't think they have any room. It's a big win for religious freedom. The same thing with the union case and the same thing with the recess appointments. Sean, they may try, and I'm sure they will. We're going to have to be vigilant. But at the end of the day, the president was checkmated today.
All right. Thank you,
You know
Jay.
what else, Sean, I have to say? They are still waging a war on the nuns. The Little Sisters of the Poor are still being fought by the government in the lower courts. So this war is not over. We still have to win those nonprofit cases.
All right, guys. Hannah and Jay, thank you so much. Appreciate you being here. And come